In allegations against Samir Wankhede, questions of religion, conversion, ineligibility for Supreme Court quota. The list of officers on the website of the Department of Personnel and Training, which allowed services to those who cleared the civil service examination, shows Wankhede was ranked 561 in CSE 2007. Maharashtra Minister Nawab Malik has alleged that the Samir Wankhede Mumbai Zonal Director Narcotics Control Bureau, who is in charge of the case against Shahrukh Khan's son Aryan, benefited from the reservation for scheduled caste despite being Muslim and ineligible for the quota. If the allegations are proven, Wankhede could lose his job. The list of officers on the website of the Department of Personnel and Training, which allots services to those who clear the civil service examination, shows Wankhede was ranked 561 in CSE 2007. He was selected as a candidate from the Supreme SC category and became an officer in the 2008 batch of the Indian Revenue Service. What is Wankhede accused of? Malik has alleged that the Dhyandev Khachura Wankhede, father of Samir Wankhede, was an SC who converted to Islam before marrying Samir's mother, Jahida Begum. Samir was born in 1979 and Malik has released the birth certificate which records his father's name as Dawood K. Wankhede. Malik has claimed that Samir was raised as a Muslim and has released the purported Nikmana, the document on which two Muslim partners entering into a civil union must sign to legalize their marriage, dated December 2006, which shows his name as Samir Dawood Wankhede. Malik has alleged that Samir, a Muslim, was elected in the CAC under the Supreme Court quota to which he was not entitled. What are the rules of religion in eligibility for the Supreme Court quota? There is a 15% quota for Supreme Courts in government jobs, but Hindus SCs who convert to Islam lose their SC status and are no longer eligible for the quota. A brochure on the DOPT website lays down position on SC status and conversions. A person shall be held to be a member of a scheduled caste or scheduled tribe if he belongs to a caste or a tribe which has been declared as such. No person who professes a religion different from the Hindu or the Sikh shall be deemed to be a member of the scheduled caste. Further, a person belonging to a scheduled caste or scheduled tribe will continue to be deemed as such irrespective of his or her marriage to a non-scheduled caste scheduled tribe. However, convert or reconvert to Hinduism and Sikhism shall be accepted as a member of scheduled caste if he has received back and accepted as a member of the concerned scheduled caste. The Constitution Order 1950, which lays down that no person professing a religion different from the Hindu or Sikh or Buddhist religion can be deemed to be a member of an SC, has been amended several times. The original order under which only Hindus were classified as SC was amended to include Sikhs in 1956 and Buddhist in 1990. No such religion based bar, however, operates for STs and other backward classes. The brochure on the DOPT site says the right of a person belonging to a scheduled tribe are independent of his or her religious faith. Petitions have been filed in the Supreme Court seeking the inclusion of Muslims and Christians in the Supreme Court category. In 2004, the Center for Public Interest Litigation challenged the legality of the provision by which people professing and converting to religion other than Hinduism, Sikhism, and Buddhism were deprived of reservation benefits. In 2008, National Commission of Minorities concluded that there was a case for inclusion Dalit Christians and Dalit Muslims in the Supreme SC category. In January 2020, the Supreme Court agreed to examine a plea by the National Council of Dalit Christians to make government affirmative action program religion neutral. The plea is pending before the court. In intercaste marriage, can mother's caste be the caste of the couple's child? The child carries the caste of the father and caste certificates are issued on the basis. However, courts have taken note of the surroundings in which the child was brought up. In Ramesh Bhai Dhabai Naika versus State of Gujarat 2012, the Supreme Court ruled in an intercaste marriage or a marriage between a tribal and a non-tribal, there may be presumption that the child has the caste of the father. This presumption may be stronger in the case where in the intercaste marriage or a marriage between a tribal and non-tribal, the husband belongs to a forward caste. But by no means the presumption is conclusive or irrefutable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. In 2006, the Minister for Social Justice and Empowerment, Meera Kumar, proposed that children born of intercaste marriage should get SC status if either parent belonged to a scheduled caste. A proposal was to be placed before the cabinet in April 2008 but was withdrawn at the last time. There was resistance to the suggestion from many quarters, including National Commission for Scheduled Caste. What can happen if a caste certificate is found to be false? A DOPT circular of May 19, 1993 says wherever it is found that a government servant who was not qualified or eligible in terms of recruitment rules, etc., or has furnished false information or produced a false certificate in order to secure appointment, he should not be retained in service. If he or she has become a permanent governor servant, if the charges are proved, the government servant should be removed or dismissed from service. Samir Wankhede may face an inquiry and may be dismissed if his SC certificate is found to be false. However, the matter is currently very politicized and clarity is required on several questions. Whether his father was a Muslim when Samir was issued his certificate, whether his father converted to Islam to marry and then reconverted, and if so, when, whether Samir changed his religion to Hinduism just to receive an SC certificate. Thank you.